Yes,
But that's
Senator.
not what you just said. You think the supremacy clause applies. The supremacy clause applies. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
The Florida legislature, Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can.
In a sharp Senate Judiciary Committee exchange, Senator John Kennedy grilled judicial nominee Judge Jordan Pratt over his understanding of constitutional law, particularly the Supremacy Clause, and whether state courts can ignore federal constitutional rights. As Pratt struggled to articulate a clear answer on the principle of adequate and independent state grounds, Kennedy interrupted with his signature line, "Do you want to change your answer?" Under pressure, Pratt admitted, "I would like to change my answer," marking a rare public concession during a confirmation hearing. The moment showcased Kennedy's no-nonsense style and highlighted the rigorous scrutiny judicial nominees face, underscoring the importance of deep legal knowledge for those seeking lifetime appointments to the federal bench.
What's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required anytime that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required anytime the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy
Do
Clause.
you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
But
Senator.
that's not what you just said. You think the Supremacy Clause applies. The Supremacy Clause applies.
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature, Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize, I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say this group, we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a legislature
Tell
could
me first if a state can do that.
Yes, a state can, for example, require a driving age which discriminates on the basis of age. To say, for example,
When can a state